Good morning and welcome to Coffee with the Commission. I'm Wendy Alkire, the Assistant Executive Director, and today I have Marshall Simmons with me. He is the Chief Investigator. Marshall, would you mind introducing yourself and just telling us a little bit about your background?
Sure. From Columbia, South Carolina. I've got an undergraduate degree and a master's degree there at Carolina, and then hired on with the DEA and was with DEA for 31 years and had tours in Columbia, South Carolina, New Orleans, and then to Montgomery, and then FBI headquarters, and then Interpol, and then back to Montgomery. And then I've been here at the Real Estate Commission for 7 years.
7 years. Congratulations. That's a long time. What an extensive background you have. Thank you for sharing that. So Coffee with the Commission is our way of connecting with you, the licensees, and we want to make sure this is as interactive, let's try that, interactive as possible. So if you have a question for us, if you could please use your raise hand icon and we will call on you and you'll be able to ask your question. Just keep in mind that sometimes it takes us a minute to get to you, so just keep that hand up and we will get to you as soon as possible. So today we're going to be discussing common violations that we see here at the Real Estate Commission. So to get started, Marshall, maybe you could tell us the #1 complaint that we receive here at the Commission.
Absolutely. It's usually involved advertising, and most of the time we see it's a competitor and they're jealous of somebody else's success or their advertising mode, and we get complaints about font size and that kind of thing.
Okay, so advertising, there are a lot of requirements for advertising. I would say maybe the main one is making sure that the broker's business name or the company that someone works for is in a font size that's as big as or bigger than really any other font size in whatever type of advertising. Would you say that's kind of the #1 thing to keep in mind?
It is. That's probably the leading type of advertising complaint we get. Is it the broker's information is missing, or the company information is missing, and so we see a lot of those that come in like that. The resources that are available on our website, there's a lot of things there that you can find under Briefly Legal, and if you use the search bar, it'll bring up all the options for a lot of different trainings that you could use for your company.
Excellent. And I do believe that recently, after the addition to regulations in advertising, the staff added I'm going to say it was called Basics of Advertising document, and that can be found on our website under the Laws tab and then Statutory Changes. If you scroll down under, I believe it's additional resources, you'll find that document, and that really is really helpful for licensees to kind of remember all of those requirements for advertising. So let's talk a little bit about issues that we're seeing in real estate transactions. So what are some of the issues that we see regarding real estate transactions in the complaints that we receive here at the Commission?
We get a lot of complaints about how earnest funds are handled. That's probably one of the primary things we look at. We do draw a line between the earnest funds, and we can't order that those earnest funds be returned to a consumer. That has to be handled civilly. And we go through those issues with each complaint that comes in regarding any cash or earnest funds complaints.
Okay, and that's so important that the earnest money, funds held for other people, it's so important that it's handled correctly. So a licensee who is not a broker receiving any funds would then turn that money over to their broker, and the qualifying broker then has certain requirements for their trust account. Is that correct?
Correct.
Okay, great. So in addition to that, I know that we have a lot of other transaction-related issues that come in. Are there any that come to your mind when we talk about that?
Yes, we get also probably a close second to that are consumer complaints about the forms that they're signing. They don't understand the form. They don't understand, like, for instance, repairs that they had agreed to make, that they signed. The form may have just been sent to them and said, let me know if you have any questions. But they don't read it, and we tend to get too busy. And so I think, if we slow down and take that time to go over that document carefully, because they don't understand a lot of times what they're agreeing to in an addendum that was maybe rushed at the last minute before closing.
I know when I've seen some of the complaints that come through, a lot of times that's related to things like repairs that are done on the property. Somebody doesn't really understand what it means when they're negotiating those repairs, and the other side doesn't have to make them. So just being really careful to explain that to your buyers and sellers and having them understand. I can see where that would be really important.
Very important.
We always think that buyers and sellers understand the real estate transaction as a whole, but really most people aren't buying and selling a house other than, every, I don't know what the average is, 10, 15 years. And so what they remember from their last transaction may not necessarily be the same as the one they're in currently. So just something to keep in mind, I think, when we talk about helping buyers and sellers navigate that big purchase or sale.
And if we could just say, talk to that consumer and go over the who, what, when, where, and how. Who's responsible for paying for those repairs, and when are they going to occur is very important.
Absolutely. So another thing that comes to my mind when I talk about the complaints that we receive, many of our complaints have some kind of allegation regarding misrepresentation. Now, misrepresentation can mean a lot of different things. I've seen it classified as the licensee didn't disclose something. I've seen it classified as the licensee lied to me. I've seen it classified as the licensee didn't protect my interests. And there's lots of other things that people kind of put into that misrepresentation category. Is that something that we see a lot?
We do. We see that a lot, especially when a consumer will make a complaint about, my licensee, my realtor, was actually representing the person selling the house, and I didn't know it. And we'll get all the forms in, and they actually sign the document that showed dual agency. Mm-hmm. So they don't look at what they sign. So you got to make sure, again, to go over those forms and make sure they understand this is what you're signing. I'm also representing the person selling this house.
And I'm glad that you brought that up. It's really important to make sure that your buyer or seller, or if you're assisting both sides, that they fully understand who you are representing and whose best interest you're working in, to make sure that they kind of can bring that back to real life scenarios. Because just to say it in the beginning of a transaction, sometimes they don't remember it the way that you maybe explained it, and just continually letting them know that you're on a certain side or the other as far as legal representation. Anything else come to mind? I know I did a talk recently with some of our other staff, and one of the things that was really interesting to me was the licensees were very interested in talking about closing cost estimates. Can you tell us a little bit about that and the requirements?
The requirements when an offer goes back and forth and closing cost statements are done, we frequently find, our auditors find this actually when they're reviewing the files during an audit, and they'll bring it to our attention where they're not completed or they're completed after the fact. So we do get some complaints about that as well, that we end up having to do a formal complaint on. So we need to make sure to get them done on time, and each time that contract goes back and forth.
It's really important. If I'm certain some of the licensees on our call today can tell us about a time that they got to closing and either the buyer didn't have enough money or the seller didn't have enough for their payoff. Sometimes it's a matter of somebody going out and buying a new car when they really shouldn't do that, and it messes up with their debt to income ratio. But sometimes it's because they don't understand those costs and how quickly they add up. And so making sure that they understand that can really save a deal when you get to the end. So
and don't wait till the day before closing.
Definitely make sure they know as soon as possible. That's absolutely right. I think the law states that that you have to give those closing cost estimates to a buyer at the time that the offer is presented. So that would be an offer or even a counter offer, during negotiations.
Correct.
And then to a seller, the law says at the time the offer is presented. Is that correct?
Yes, ma'am. Correct.
Okay, so that's just a good thing to remember as a licensee, that that would be the appropriate time. Definitely not the day before
No.
closing. That we're a little bit late in the game for that. So I'll pause right there just to see if we have any questions from our audience.
Good morning, and thanks for taking my question. My question is related to the topic. I would like to know, do you have a list of common violations for property management? I work for a national institutional property management firm and would like to know what you see coming across.
Yes, ma'am. If you'll go to the search bar on our website and just put in property management, it's going to pull up a lot of resources for you. There's a video under media, and then there's some documents under briefly legal that list top property management issues. Also, I'd suggest you go to take a look at, there's an audit checklist that would be very helpful in property management, to take a look at that audit checklist to make sure you're following that protocol.
Does that help you, Lisa? Do you know how to reach our website and to get those resources?
Yes, I do. Thank you so much, and that does help me.
Okay, great. And if you have any specific questions, something that you're struggling with in compliance with the law, please reach out to our legal staff. We love to help people before it becomes an issue. So if you have any specific questions, please send us an email and we'll be happy to help you with that.
Will do. Thank you so much.
Thank you. So we have a question from Doris. Doris, what can we help you with today?
I'm just curious with regards to of the public to consumer signing documents. That has been a recent conversation in our office where, agents do buyer consultations, walk them through everything, go over the RECAD, sign their BBA, and then, at the end of the day, things don't go their way, and all of a sudden they're upset and they're like, well, I didn't understand what I was signing. I went out of this BBA. That's a cop-out, and I feel like as much as I'm all about educating the consumers, and I love these buyer consults before you go into doing anything, but where does it stop? Where's the protection for the agent, or what else could they do to ensure that the consumer really understood, right? I mean, I feel like it's a tough subject sometimes.
It is a very difficult subject, and we certainly know that here at the Real Estate Commission. When we look at that type of violation from our perspective, we're looking to make sure that the RECAD was presented, that the agency agreement was signed at the appropriate time and has the appropriate items in the document. And although we have sympathy for a buyer who maybe didn't understand it, but if all of the legal things have been done, it's most likely going to go towards the licensee that they did everything that they could. Now, I can tell you that legally, that is probably something you'd want to talk to your own attorney about to protect yourself in the legal realm, because certainly that's not something that the commission does here. We're looking at license law violations, but we certainly do look at those documents. We will talk to the licensee and ask what conversations they had, and we're going to look at all of that supporting documentation as proof that things were done correctly. Did you want to add anything to that, Marshall?
Yes. If you have a situation also, I'm reading into your question a little bit, but if you have a situation where, let's say a consumer declines to sign, you can simply write that in, decline to sign, and sign that yourself and date it and have a witness preferably.
That's a good thought, because sometimes people won't sign those documents. So, and that's another good question to either talk to your qualifying broker or your attorney, just to make sure that you're protecting yourself. Because we've seen things where, from our perspective, things were done correctly, but then, if you're still defending yourself in a court of law or on the civil side of things, that can be very difficult also.
Right.
Thank you for your question.
Thank
you for your question. We appreciate it. It looks like we have a question from, I can't see the name, Bobby. Bobby, do you have a question for us?
Yes, this was about the estimated closing costs. just to clarify, we need an estimated closing cost for every price change, like negotiating that initial contract, correct?
Yes.
Okay, perfect. I just wanted just to clarify. Perfect.
I'm glad you asked that question because we get asked that a lot. And really, to just think about, the end of the transaction, and as many times as you can put that number in front of your buyer or seller, just to make sure that they're prepared when it comes to the end. Because, when deals fall apart, we all know how messy that can be, and that's not our goal. And information keeps people, kind of going towards the right direction. So thank you for that question. Looks like we also have a question from Sean.
Okay, good morning. So this is going to be a two-part question. The last point she brought up. So first, on the net sheets, is it required by the Real Estate Commission to do a net sheet anytime there's a price change, or is it only during when you list it and any negotiation of the price itself?
So it should be any time that there's if I'm understanding your question correctly, it should be any time that there's a price change, because anytime there is a price change, that is a negotiation. And so we need to make sure that the buyer and the seller understand what that price change is going to mean to them as far as closing costs. And it doesn't have to be, it doesn't have to be anything, too outrageous. They just need to understand when they're signing to say, yes, I'm going to make this price change in my deal to purchase or sell. They can put it together in their mind. Oh, this is going to cost me an extra $1,000, or this is going to bring in, $2,000 less than I was expecting. Maybe I'm buying another house that could impact their purchase on the other end. So yes, it should be done anytime there is a price change.
Okay, we require it. I was told by someone else that it was only at listing and when you got an offer. We have an office policy that a net sheet is required anytime that price changes, whether it's during negotiation or when you change the price itself. Okay, second question. On the net sheet, one thing that we also do as an office policy is we like to use the net sheet that's through Alabama Realtors Association, or the Alabama Association of Realtors. But my question is, there's a lot of things on here that we don't potentially know when we fill out this net sheet initially. Like if we're making an offer, or if we have the seller and we do the net sheet, there's a couple of things on here like the deed prep and recording fees and things like that that we don't know at the time we initially make the offer.
Mm-hmm.
Is there any potential to get in trouble by not filling that out? My assumption is if we don't know it, we can't put it on there, and we should fill it out to the best of our ability. But I just want to make sure that, because you're not supposed to go back and do the net sheet after the fact, but is it okay if we go in and fill some of those things out once we find them out? It may be 4 days after the initial offer was made.
So the net sheet is to be provided at the time the offer is presented or at the time the offer is written for the buyer. And so I would say that if you're not sure of those fees, you could do a range. I've seen on some of those where, for example, if a doc prep fee runs anywhere between, excuse me, because I've been out of real estate for a long time, so I'm probably going to have this number wrong, so maybe it'll give you a good chuckle. But maybe a doc prep fee is going to run $500 to $1,000. It would be okay to say it's estimated between this range. So you could maybe work with a title company or a lender to find out like what would be the low amount and what would be the high amount, so that someone can kind of see, because they still, before they sign that agreement to take that amount as a seller or to pay that amount as a buyer, they really need to understand what it could cost them at the end. Now, if you aim high and someone doesn't have to pay that much, let me tell you, they're a lot happier than if you aim low and they didn't have enough money to get to closing, or they didn't understand that there were other fees that weren't listed on there. Okay. Does that kind of help you?
Yep, absolutely.
Okay, excellent. Did you want to add to that?
Yeah, let me add
Sure.
to that. We get this, that's a great question. Thank you for that. We get a lot of these type of questions that when we get a complaint about either your first or second question, I look at those as qualitative type issues. They're not really quantitative. And the reason I say that is because the violations in license law that address what you're talking about, what your questions go to, is things that was there negligence? Did you put the wrong amount in? Did you intentionally do something dishonest to mislead the consumer? So as long as you're doing what you just said, and you're doing it to the best of your ability and based on what you know at that time, you won't have an issue.
Okay.
I hope that helps.
Thank you for your question. We appreciate it. Before we move on, are there any other questions? Okay, great. Keep them coming. We love to get your questions answered if we can, so thank you. So I want to switch topics just a little bit and talk about AI. AI is really a hot topic in real estate as well as lots of other types of businesses. So as licensees are using AI more and more, they're using this AI in advertising. They're also using it in helping fill out documents and prepare those. Do you have any advice for a licensee that's using AI?
Sure. I think the best thing that we could suggest is to not delegate responsibility to AI. Look at the document that you've prepared because you're responsible for it. And it's a great tool, but you still got to check it. Don't just send it out and say, let me know if you have any questions, because we see that. So still check your work. Slow down. That's my mantra. Slow down. Look at the document, even after AI's assisted you in preparing it, because your name is at the bottom line.
And that's very true with not only documents, but also advertising. I was at a conference a couple of weeks ago, and they were talking about how licensees are using AI to enhance those photos. And sometimes it's not even intentional, but it can cause a misrepresentation in your advertising. If you, for example, I know that people have added lights to an outside area. It makes it look like it's bright and warm and all those things, and there really aren't lights out there. Or some people have used it to take out like shorten a window or, you know, make things look a little nicer in their photo. And I think a lot of times they're using that just to make the photo look really nice, and they're not thinking about what a misrepresentation that can be of the actual property. So maybe just keeping that in mind also when using it in advertising.
Absolutely, and there are several sections of advertising license law about misleading or deceptive practices. So we would compare and what was actually posted versus the truth.
I saw one that really surprised me. There was the driveway had lots of cracks in it, and the licensee had went in and taken all the cracks and made the driveway look really nice. But you can imagine what the surprise that was when the buyers went and viewed the property, and it had deteriorated overnight, I guess.
Or pools. Pools
So,
are popular too.
Mm-hmm.
You know, you see a picture of a bright, crystal clean pool one day, and it's viewed the next day, and it's green. So.
Oh, my pool does that sometimes, so I can relate. So thank you with that. I know that AI is a really hot topic for licensees, and really we suggest that you work with your qualifying broker to know what your parameters are when you're using AI, and really just think about it is a great tool. It is something that can really help, but there are some issues that come up with, you know, I've heard things like sometimes advertising, you got to be careful. You don't want to end up with a fair housing violation. You don't want to end up with some kind of discrimination that you can really tarnish your reputation just by using an AI model that helped you create some of those creative things that licensees like to use. So just be aware out there. We don't have a lot of guidelines on that as of yet, but it is something we are thinking about here at the Real Estate Commission. So let's talk a little bit about failing to report. I know some licensees have had some issues with maybe some misdemeanors, even some felonies, and there is a requirement for a licensee to report that to the Real Estate Commission. Can you tell me like when they're supposed to report and what types of things?
Sure. Anytime that you have an arrest, not necessarily a speeding ticket, but if it generates a fingerprint and you're actually taken to a jail, that's an arrest that has to be reported. Also, civil suits have to be reported as long as they involve a real estate transaction. They have to be reported within 10 days.
Okay.
The thing that we see, companies as well. So if a company is named in a civil lawsuit, that company has to report that civil lawsuit within 10 days.
And it's a 10-day written notification, is that correct?
Correct.
Okay. And so, just keep that in mind. And if you're ever in doubt, it's better to just make the disclosure and we'll tell you we're not interested in, the fact that you were speeding. But if it has a reckless in there and you're arrested for it, then we may be interested in that. So just keep that in mind and please reach out if you're in that situation or talk to your qualifying broker. Let's see. So, Marshall, maybe you can tell the audience how many complaints we receive in a year.
Absolutely. For instance, last year we had 563 investigations opened. This year we're up to 162, so we're on track. A lot of those deal with what I've just described, earnest funds, property management issues, that kind of thing. The good news is we don't. A lot of those aren't bad check cases anymore. Probably a lot of licensees are aware of that's been changed too. That's also on the website. So a lot of those have to do with advertising, the property management issues, earnest funds, disclosure, latent defects. A lot of consumers make complaints about defects once they get in the house and that kind of thing. So got quite a few cases that are open.
I'm glad you mentioned the bad checks. So the commission in the past has had a lot of issues with bad checks, and it was quite a process before. So just a real short version of the update in the law, if a licensee is to give a bad check, and when I say bad check, whatever form of payment does not go through, it could lead to an automatic suspension of their license. Is that correct?
That's correct.
So we really don't deal with that. It's now automatic in the law. I think someone has 30 days to make good on the funds that they've provided to the commission. And if that is not done, they are automatically suspended. And then after 6 months, I believe their license is no longer valid. They can't use it. I mean, they would have to start over. So it's very important to make sure those funds are appropriate. And it's a good time to talk about that because this year is a renewal year. And so we will start renewing licenses mid-June, I believe.
Correct. Yeah.
Mid-June all the way through October, September 30th, and then there's a late fee after that. Is that correct?
Yeah.
Okay, so be looking for that. Make sure that you get your CE done timely and that you get the process done on time so that you can continue to work in real estate without any interruption.
Don't wait till the last minute.
It's a good time to be setting up those CE courses now, and that way when it's time to renew, you'll be all ready to go. Let's see. So when we do receive a complaint, can you tell me a little bit about what happens at that point from our perspective?
Sure. We evaluate the complaint to make sure we've got jurisdiction, and it's not something that it's a landlord-tenant issue or something that we don't have anything to do with. And once we do that, we put it into a database. Everything's tracked. It's then assigned to an investigator. The parties that are involved, both the complainant and the respondent, are notified by telephone call and email. We request a statement. We're trying to get both sides of the story, so we get a statement and any documents relating those allegations. And then we build on that and say, okay, who else is involved in this? Was there a listing agent? Was there somebody else involved in this transaction or whatever the complaint is that we need to get their statement? And we go from there to get the full picture of what this complaint's about. Once that's done, we write up our findings, and then that goes to our general counsel, who reviews the overall file. Once I review it, and I look for anything that's missing. I look for any missing pieces that maybe we need to interview somebody, issue a subpoena for bank records or something else. But once that's done, it goes to our general counsel. We, she looks at those and determines, yes, there's probable cause. And at that point, it goes to an attorney, and they look at the next scheduling time we have available for the commission to actually hear that complaint and for the respondent to present their side of the story.
So that's something that we always want to make sure that licensees understand. If they have a complaint that is filed against them, if it's not in our jurisdiction, we would close that without, I mean, we don't move forward with anything outside of our jurisdiction. But we always give the licensee an opportunity to provide documentation, to provide copies of correspondence, to provide their side of the story before we move forward, because we want to make sure we understand exactly what happened in that transaction. You know, there's always several sides of the truth. There's the truth of this side, the truth of that side, and somewhere in the middle there is truth. And we try to get as close to that as possible before we ever cite a violation against a licensee. So it is quite an undertaking that we do here when we look at all of these complaints that are filed with us, but we do take that very seriously.
We take every complaint seriously, and we expend a lot of time and energy on them.
So thank you for explaining that. So before we kind of wrap this up today, I would like to know what suggestions you have for licensees to help them stay out of trouble.
I'm going to go back to my mantra: slow down. Slow down. I know the closing's coming up and we got to get everything done, but go over that document. The consumer needs to understand what they're signing. And one of the questions pointed this out very wisely. What if you did that and they still file a complaint? Well, we'll see that. We will see that. But that's the biggest thing that I would suggest. Take the time to look at the resources we have on our website. Look at other resources, but slow down. There's going to be more closings. Do it right. Make sure that consumers satisfied with what you've done to assist them. That's probably the biggest thing that would prevent a lot of complaints, because it's kind of a downward spiral at that point. You don't want to spend your time and energy having me contact you to have to give a statement about it. Just do a little prevention and take a little more time and slow down.
And, you know, something that didn't come up in today's talk that kind of just popped into my mind as you were saying that is the programs that allow people to sign documents digitally. Those can be very difficult for someone who is not used to using those types of programs. A lot of times it's easy to just click sign next, sign next, sign next, and they're really not taking the time to understand there could be several pages in between what they're signing, and from the perspective of the person signing it, they may not understand that they're missing all of that valuable information. So that's another area that I think that sometimes it's hard to remember, that we understand it when we use those programs a lot, that you need to scroll up and you need to kind of read what you're signing, but somebody who's not used to that may not understand that that's something to protect them. So maybe explaining that a little bit more if you're going to use those digital signature programs.
And they're great, and they're a great time saver, DocuSign, etc. And we review those documents and the logs that they provide us when we get a complaint in that area. But slowing down, and even, you know, technologically challenged persons, and, you know, this is a big transaction. This is the biggest transaction that people are going to have in their lives. So just slow down, go through DocuSign, go through that app that's being used, whether you have to do it in person, take the time to go to that person, or even a FaceTime call, and slow down and explain step by step each line, so that they understand that they're great tools, but slow down.
Excellent, thank you. Are there any questions for us? Looks like we do have a question. Excuse me, Sean, thank you for your question. What can we help you with?
I'm sorry, I really don't want to beat this net sheet dead horse, but I want to make sure that we're following the law completely. So I looked up the rule on estimated closing statement, and this is what it says on the AREC website. It says a licensee in a single-family residential sales transaction must furnish to his or her client, consumer, or customer a complete estimated closing statement each time the licensee presents a written offer or counter offer to the client. So it doesn't specifically state price changes. And I think that's where the other agent that reached out to me got that from. But what you're saying is, and like I said, we do it just by matter of form because I think the consumer needs to know. But per the license law, it doesn't look like it's required. And, for audit purposes, you wouldn't get in trouble if you don't have a net sheet when you change the price of a listing. Is that correct?
Okay, I may have misunderstood the question. You're talking about a listing, which there's no requirement to do an estimated closing costs at the time of listing. If you want to do it at that time, that's fantastic. That's great. That's giving your
Correct.
seller information. If you don't do it at the time of price change of a listing, then that is not a violation because it's not required. When it was asked about price changes earlier, my mind kind of went to things like the appraisal came in low, so the price of the property had to change, or they negotiated repairs and so they changed the price versus having repairs done before closing. So that's where I went. So I apologize if I gave the wrong information, but yes, thank you for clarifying that. The listing does not have to have an estimated closing statement or closing net sheet. I'm sorry,
Net
whatever
sheet.
y'all call
Yeah.
it in the field there. If you do it at that time, there's absolutely nothing wrong with that. You're just giving somebody more information and having them be prepared on what that would mean if they got a full price offer. But the time to do that with the seller would be when you're presenting an offer or a counter offer, or with the buyer when they're writing an offer or looking at a counter offer. So thank you for the clarification. I could see where that was confusing.
Yeah, that's fine. And also, what about commercial? Because that is not specifically listed in this. So are net sheets required for commercial listings, offer presentations, anything to do with commercial?
Nope. Nope, they are not. You certainly
Okay.
can do them if you want to, or if your client asks you, but they are not required.
Here's one
Okay.
kind
Excuse me.
of follow-up to that. We do get complaints about consumer complaints. Well, they didn't present my offer. I had a higher offer. They don't know that there was a cash offer with no contingencies. So we have to pull the records and take a look at, was this consumer's offer actually presented, and look at the logs. And as part of that, if there was also a net sheet there, a potential net sheet, it would further bolster that yes, this was presented. They actually looked at the net sheet. Just more documentation that we would see that would actually help us to close it out quicker.
Okay. Perfect. That answers both of those. Thank you.
Excellent. Are there any other questions? Okay, well, if you think of some questions, please reach out to us. We are more than happy to answer those, and we would like to help you before it becomes an issue. Here at the commission, that really is our goal, is to help licensees. And that's why we put out all of those documents that kind of give you some guidelines. And we also try to do things like this, talk to you live, and I'm going to say in person, but you know what I mean. So I want to thank you for joining us for Coffee with the Commission today. It has been our pleasure to, set this up and have the Q&A with the licensees. If you have any questions for us, you can reach us at 334-242-5544, or you can also reach us at arec@arec.alabama.gov. You can connect with us on social media on Facebook, X, Instagram, LinkedIn, and YouTube. Our name on all of those is at AREC Alabama Gov. There's no spaces or no periods in that. It's all one. Also, make sure you check our Facebook. Make sure you check our website for all of the resources that we have available. And if you can't find something that you're looking for, please reach out for us. Thank you again for joining us, and we hope you have a good day. Thank you.